My lords and my ladies, in our rejoinder, we will do the following. First, my learned friend, Mr. Otiende, will address your lordships and my ladies for 10 minutes.
Yeah.
And then my learned friend, Mr. Firoz Norji, will address the court for about 40 minutes, and I'll have a balance of about 5 minutes or so.
Very well.
So, Mr.
If it may please, my lords, I will be very brief for this part. My lords, I will restrict my reply essentially to the first and second respondents, but generally say, my lords, that in the presentation by all the respondents, they have created an imaginary case for the petitioner and proceeded to answer it. Cases we have not presented before you. I will not comment on that part. My lord, allow me to say with great respect that between the 8 lawyers representing the first and third respondents, they have treated not only this court, but the petitioner and the Kenyan voter with contempt. My lords, first, the essential question that was demonstrated and must be asked were Form 34As generated, scanned, and transmitted electronically and manually to the National Tallying Center, as the law requires. In their written response, paragraph 20D and 24A, they say they did. All of them. In their address to you, they admit they did not transmit at least 11,000 of those forms. But then they do not stop there, my lords. They tell you that whether those forms and images were transmitted or not is irrelevant, because the announcement was based on Form 34Bs. By so doing, they admit to have breached the law. By so doing, they endeavor to run away from the results transmitted electronically. My lord, they then tell you, and it comes to the question, therefore, that if it was manual, it was not based on the electronic transmission, were all the Form 34As transmitted to the National Tallying Center by the time of the declaration? To that, then, the answer, no. But they add, however, all of them were eventually transmitted after the declaration of the final result. And to that, then, it invites the necessary legal question that if at least 11,000 Form 34As were not at the National Tallying Center, on what basis? And then the chairman says, my lord, it was on the basis of Form 34B, as received from the Tallying Center. And then they add, my lord, contrary to the law, seeking refuge in the minor care decision, that there is no obligation on the chairman to confirm that the results shown on 34B reflect the results on Form 34A. My lord, that is contrary to the minor care decision. The care decision says the results as pronounced at the polling station is final, which means, my lord, what the chairman must look at is Form 34A, and then check without varying that the entries match with 34B. Then he can proceed to declare. He did not do that in this case by their own admission. But they say it does not matter because they eventually arrived anyway. My lord, it begs the legal and legitimate question, what was the hurry? The law allows the chairman 7 days. He hurried to announce on the 3rd day, 2.5 days. What was the hurry? In the end, my lord, the results are neither based on an electronic transmission, nor are they based on a manual delivery of Form 34As or Bs. It's even worse, my lord. The chairman has the audacity to tell my lords in the response that he saw all the 290 Form 34Bs Then here he comes to admit that he did not tally the ones for Nyando. That is grave. That is very grave. My Lord, the IEBC tells you, the question is posed to them, that the law requires that the results be transmitted immediately as they come in, randomly. As we demonstrated, my Lord, the results that were transmitted and displayed did not come randomly and certainly did not indicate the respective polling stations. The third respondent has endeavored to demonstrate to you the polling stations that transmitted the initial results. How the third respondent got that information is up to them, but it is not information from the public portal, and that is not disputed. But more importantly, the law requires that that information, that result must be verified and accurate. It must reflect what is in 34A. It is clear, and it was demonstrated, my lords, that the results in this case do not reflect that. What does the IBC tell you? IBC first, in their papers, they call that is a mere statistic. It is irrelevant. In court, my learned friend Mr. Nyamodi says that is mere data. When pressed by this court, it says it is a figure that was formerly called provisional result. My lords did ask them, so what are they? They could not answer. My lord, these are supposed to be results by law, transmitted electronically, and you cannot transmit inaccuracies and run away from it. But more interestingly, and sometimes this happens when you have many counsels, to the very basic question, were all the 34 A's transmitted eventually to the National Tallying Center? My learned friend Mr. Nyamodi says yes. Issa Mansour comes later and says no, there is no requirement for delivering from 34 A's. Hence the question of returns is irrelevant. My lord, this is the same IEBC addressing you on such an important matter. This IEBC, my lord, wants you to believe that the chairman has no role in verifying what he declares. That because the Mainia decision said the results are final, that the chairman must robotically pick them and pronounce without verifying. I submit, my lords, that that cannot be the position. But more interestingly, my lord, and I have 2 minutes to go for my own time, they transmitted these results to the entire public, a member of an expert, given those very results, analyzed them and presented them to you. Not the IEBC, not the third respondents have disputed the entries that were provided to you. Those entries tell a story through a regression analysis, an impossible story. What does the IEBC tell you and tell this country? That is Pythagoras' theorem. People paid by the taxpayers. Lawyers engaged who will be paid by the taxpayer. Some of whom are already public officers. That is Pythagoras' theorem. My lords, I respect if you submit that this court and the people of Kenya must be treated with a little more respect. My lord, lastly, and this is my closing on my part, the issue and the question that my lords did ask, the difference in presidential votes and all the others. And my lord, we did show that the difference runs into 577,000 votes. And my lords did ask the respondents the question, what accounts for that? The IEBC, my lord, through its lawyers, stand in this court and tell you with a straight face that the difference is because of the diaspora votes and the prisons votes. Their own documents show that the total number of diaspora votes is 4,000, their own documents. We are not even asking how many voted. The total number of registered voters in terms of the prisoners is 5,000. The exact number, my lord, is 5,528. Diaspora is 4,393. And they stand here, my lord, to tell you that those numbers, which come to less than 9,000, is why the president has 570,000 votes more. My lord, I submit that the contempt and unseriousness with which the IBC has treated this petition and this court reflects the unseriousness